Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by Serenade e-Immigration. This is for all the paralegals out there working alongside excellent attorneys. Serenade and e-Immigration know that you're not just filling out forms. You're managing timelines, catching errors, supporting families, and keeping attorneys on track. The team at e-Immigration just put out the 5 essential skills that set the best immigration paralegals apart in 2025. Ethical, detail-driven, and tech-savvy. Here's how the best paralegals are doing it all. Read more about it at get.eimmigration.com/resources, or of course, click on the link in the show notes. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Welcome to the podcast, friends. Historically, July and August have been heavy months on the pod. The circuits just seem to go wild during the summer. Hot circuit summer, dare I say? The previous winner for most cases in a week was an 11-case week from 2022, August. Well, friends, we have a new winner. 12-case week! 12-case week! Hooray for the cases! Let's do it. That's what I do, right? There's lots of news this week, lots of immigration news, lots of crazy news, lots of depressing news, and I could, of course, thank my lovely patron and sponsor supporters, who I do thank. But you know what? Let's just get to it. Let's feel the good. Let's take a deep breath. Remember why the immigration bar kicks butt, and take a dive into the latter half of this insane year with rejuvenated gusto. Sounds like a delicious dish or accoutrement, if I'm being honest. Keep that thought with you as you join me on our 12-case journey this week. Our first case of the dozen is Guandique-De Romero v. Bondi, published by the Fourth Circuit on August 13th, 2025. This case is about ineffective assistance of counsel. Miss Guandique-De Romero is from El Salvador. In 2012, a gang member told her husband that he'd kill the husband unless the husband paid the gang $3,000. The husband reported this to police, but the police told him that filing a report would only make things worse and he should just pay. When the threats continued, the husband fled to the United States, leaving Miss Guandique-De Romero and their 2 young children behind. Gang members started extorting Miss Guandique-De Romero in March 2016. They said they knew that her husband was in the United States, so she should pay. They said they'd kill her and her children if she didn't. So she went to a bank to withdraw money while the gang watched her do it. Same thing, she told police, and they told her keep paying or flee. After a couple more payments, extortion increases, death threats, and demands for sex, Miss Guandique-De Romero fled too. Shortly after, the gang approached her brother asking where she was, and the brother said the United States, under pressure from the gang. In removal proceedings in the United States, quote, she told the attorney that she'd been sexually extorted, not just financially extorted, and other details. But instead of including the information in the asylum application, he simply responded that he was the attorney, that he knew what he was doing, and that Miss Guandique should let him do his job, end quote. In the asylum application, though, the attorney's basis for asylum was pretty much simply that Miss Guandique-De Romero was in the United States and could be subject to extortion in El Salvador. The attorney also didn't submit much of any corroborating evidence, apparently. The children were included as derivatives. Quote, before Miss Guandique-De Romero's removal hearing, Her attorney did not meet with her to prepare and did not inform her of the particular social group requirement. He also did not submit a pre-hearing memoranda of law, even though such a filing is encouraged by the Department of Justice Practice Manual, end quote. Citing to the PM, the Fourth Circuit does, in Yoda speak. The IJ was not impressed, saying, quote, "There's not a whole lot there," end quote, on the record. Not great. Quote, when the immigration judge asked for the proposed particular social group, Ms. Guandique-De Romero's attorney responded, "El Salvador citizens whose spouses are gainfully employed in the United States, that's the particular social group I can think of," end quote. The IG believed that wasn't a particular social group. The Fourth Circuit believes that's correct and indeed, quote, foreclosed by controlling precedent that prohibits wealth-based particular social groups, end quote. Lozano v. Holder from 2011. Nor did the IJ see a nexus. On appeal to the BIA, the attorney focused only on nexus, but didn't address the non-viability of the particular social group, so the BIA summarily dismissed the appeal. 2 months later, new counsel timely moved to reopen, claiming ineffective assistance. In addition to various errors, counsel proposed 2 neglected possible particular social groups. 1, immediate family members of William Alfredo Romero, the husband, and 2, women. The BIA denied the motion. Thought that counsel's particular social group stuff was a, quote, tactical decision, end quote, that is, the first attorney. Some other findings, too. The Fourth Circuit reversed. First, it explained, although motions to reopen denials are usually reviewed under the very agency-friendly abuse of discretion standard, the Fourth Circuit reviews ineffective assistance of counsel claims de novo. That is a big deal, and Oil conceded it. Because it's a legal issue, or I guess sufficiently mixed question of law and fact, I guess. So now we've got de novo review of whether ineffective assistance of counsel occurred. Well-framed counsel. Second, why it matters. Agreeing with almost every other circuit, the Fourth Circuit held for the first time, apparently, that, quote, ineffective assistance of counsel in removal proceedings can violate a non-citizen's due process rights, end quote. So this is a constitutionally significant issue. Technical circuit split with the Eighth Circuit, though, so what the heck? It's a Fifth Amendment, not true Sixth Amendment protection because non-citizens aren't guaranteed a lawyer in removal proceedings. But, quote, those who retain counsel tend to rely heavily on their attorney's advice because the proliferation of immigration law and regulations has aptly been called a labyrinth that only a lawyer could navigate, end quote. Or I suppose David Bowie. Misadvice or other things can lead to deportation. It's serious stuff. Dance, magic, dance. Quote, of course, it is unrealistic to expect that lawyers will never make mistakes, and sometimes lawyers make valid tactical decisions that don't work out as expected. Nevertheless, we hold that some legal assistance can be so ineffective as to deny non-citizen due process of law, end quote. This was such a case to the Fourth Circuit. To meet the standard, ineffective assistance must constitute 1, quote, a defect in the proceeding that rendered it fundamentally unfair, and 2, that the defect prejudiced the outcome of the case, end quote. That comes down, explains the court, to whether the attorney was reasonably competent. It does not turn on whether viewed as a whole, the removal proceedings were fundamentally unfair, as Oil was arguing. Indeed, quote, although other civil cases can have significant consequences, it's hard to beat the stakes of a removal case. That raises the bar for procedural protections and thus for the performance of counsel, end quote. Yes. The attorney was not reasonably competent to the panel, quote, ignorance of a point of law that is fundamental to his case combined with his failure to perform basic research on that point is a quintessential example of unreasonable performance, end quote. The first attorney's proposed particular social group was, quote, dead on arrival, end quote, under BIA and Fourth Circuit precedent. Citing the Fourth Circuit and BIA precedent not directly on point, but close enough for the court as they reject wealth-based definitions. Quote, counsel's modifier of gainfully employed was therefore a clear and fatal mistake, end quote. Nothing tactical about it. And counsel didn't even appeal the particular social group issue, remember? And there were 2 other potentially viable options, the immediate family member one and women, or perhaps, quote, El Salvadoran women living under gang control, end quote. Are y'all listening in the Fourth Circuit? quote, both particular social groups are likely cognizable under our precedent, end quote. Y'all listening in the fourth? Have I not caught your attention by using your cherished word, y'all? To the court, the record had evidence that one of these particular social groups was at least one central reason for Ms. Guandique-De Romero's persecution. And for those reasons alone, the Fourth Circuit held that ineffective assistance had occurred. Big deal, y'all. On to the prejudice required for reopening. Well, that is that, quote, there is a reasonable probability that the outcome of their case would have been different with a competent lawyer, end quote. Sounds like the matter of log and not matter of Coelho standard to me, which makes sense given the Fourth Circuit's decision in Moons v. Garland, episode 227. Easily met because, again, the Fourth Circuit believes that the two other possible particular social groups stood a, quote, reasonable chance of success, end quote. Family membership is the, quote, prototypical example, end quote, of a particular social group in the Fourth Circuit, Ninth Circuit, and surely other circuits, explains the court. In the fourth, one central reason equates to an analysis of, quote, why she, and not another person, was targeted for extortion in the first place, end quote. Big deal, y'all. Quoting older Fourth Circuit precedent, of course. As such, asserting that the gang was, quote, motivated by a financial incentive or general criminality does not answer that question, end quote. Send me to the fourth. Plus, counsel's ineffectiveness tainted the nexus stuff anyway. As to whether Salvadoran women living under gang control is cognizable, look no further than Alvarez Lagos v. Barr, explains the court, published 4 months before Ms. Guandique-De Romero's hearing in immigration court. Similar but not identical, but the panel seems convinced. All the women in sex-based stuff that happened to Ms. Guandique-De Romero supports a nexus finding to that group here. Big old remand. So congratulations, Sarah Shapiro and many others from Yale Law School for this win, as well as a whole bunch of smart folks and private bar in the Fourth Circuit. And if I learned anything from this decision, it's just how important it is to make sure that you get all your case law updates by listening to the Immigration Review podcast every week. And that is Guandique-De Romero, the Bondi. That will have been the longest and, of course, most fun case of the week. Gonna do my best to get through the rest a bit quicker on this, the massivest of all weeks. Next up is Rivas de Nolasco v. Bondi, published by the Fourth Circuit on August 14th, 2025. This case is about particular social groups. Miss Rivas de Nolasco and her 3 minor children are asylum seekers from El Salvador. She identified the particular social groups as 1, her immediate family, and 2, single Salvadoran women. Both of those, the Fourth Circuit just said, are kind of quintessential and cognizable in the Fourth Circuit, to a degree. She fears MS-13 and described a series of very scary experiences that she and her children experienced. The IJ and the BIA denied. The Fourth Circuit affirmed that, but not before engaging in some scary jurisdictional analysis. The Fourth wasn't sure whether it even had authority to review the denial of withholding of removal and cat protection, even if it had jurisdiction to review the denial of asylum, because withholding of removal and cat are separate from the final order of removal. See Nasrallah, Guzman-Chavez, and the recent rough Fourth Circuit precedent that predated Riley. Post the Supreme Court's Riley decision, explains the panel, the 30-day rule definitively isn't jurisdictional. It's a claims processing rule, explains the court. Go back to Riley for this complicated issue, guys, if you need a refresher. But let's be clear, guys, what we're talking about. The Fourth Circuit is suggesting that a non-citizen needs to appeal and then petition for review a removability finding and, I suppose, denial of asylum in the middle of proceedings before an IJ to save eventual review of the denial of withholding of removal and cat protection. Or maybe they need to appeal just when removability is established, but before asylum is denied, which of course means there isn't a final order of removal yet. It is completely insane, practically speaking, what is being suggested here. And actually unresolved, because even oil wasn't arguing for that. It might in the future, though, at least in the Fourth Circuit. Who knows? Please don't do it, guys. Please don't do it. Quote, because the government does not press this basis for declining to review the petition, we will consider the merits of the petition. We therefore leave for another day the question of the jurisdiction stripping effect when a non-citizen concedes removability but seeks asylum before the IJ, only raises the denial of their asylum claim to the BIA, and only files a petition for review following the BIA's decision, end quote. Although I believe Ms. Rivas de Nolasco also challenged withholding of removal to the BIA, so I guess this quote is a typo, it is a confusing decision. On to the merits, though, the Fourth Circuit didn't see a nexus. Even assuming the group, quote, Salvadoran females was cognizable, end quote, the Fourth Circuit didn't believe that's why the gang members demanded entry into and then hid inside her home. The court, like the IJ and the BIA before it, saw this as a tangential reason at best. The gang was hiding from police and saw her home as an easily accessible place. That was the one central reason. There can be multiple central reasons, but the Fourth Circuit didn't see a particular social group basis here. Now, Ms. Rivas de Nolasco's fifth-grade son was also threatened by another fifth grader, and it does, astonishingly, seem to be gang-related. The other fifth grader was joining MS-13. But it's not persecution, explained the Fourth Circuit, and in any event, it doesn't have enough to do with Ms. Rivas de Nolasco herself to qualify to the court to get her asylum or withholding of removal. Quote, as explained, there was not even a threat made to Ms. Rivas de Nolasco related to the other students' unsuccessful attempt to recruit the child to sell drugs for the gang. The record before us, given that it lacks evidence purporting to show otherwise, simply does not compel the conclusion that Ms. Rivas de Nolasco has been persecuted on the basis of her membership in her immediate family, end quote. That is, to her son. And for these reasons, the Fourth Circuit denied the petition for review. And that is Rivas de Nolasco v. Bondi. Concluding the Fourth Circuit's cases this week, we have Alvarez Ronquillo v. Bondi, published by the Fourth on August 15th, 2025. That's Friday, if you're paying attention. This case is about aggravated felony firearms offenses. And it was actually the last of the 12 cases published this week, and well, it took a lot for me to get my mind into the heady space. But heady I got. Mr. Alvarez Ronquillo is a lawful permanent resident from Mexico. I'm sure he's a lot of things, but for a year or two, he was purchasing firearms and then illegally selling them in Mexico, purchasing them in the United States. As a result of his unlicensed firearms sales, Mr. Alvarez Ronquillo was convicted for violating 18 U.S.C. Section 922A1A, among other statutes, and sentenced to 78 months in prison. DHS alleged that it was an aggravated felony as defined in INA Section 11A43C, illicit trafficking in firearms. Sure seems to be, not gonna lie. But the categorical approach applies, and stranger things have sprung from it. We've got a federal offense here, which usually makes it more likely that it's going to make the non-citizen removable for a federal aggravated felony provision, but not guaranteed. What does illicit trafficking actually mean for ag-fel purposes? That is the first question. Alas, poor Yorick. The Fourth Circuit agreed with Oyl that the phrase means simply, quote, unlawful trading or dealing in firearms, end quote. In so holding, the Fourth Circuit agrees with the 2021 decision Chacon v. Wilkinson from the Ninth Circuit, Episode 43, and Manner of Davis from the BIA from 1992. This has nothing to do with Chevron deference, explains the Fourth Circuit, as it must given that deference's demise. This is just the correct reading of the statute. Dictionaries from 1988 and 1994, when the term and aggravated felony provision were placed into the INA, confirm the Fourth Circuit's definition, explains the court. Mr. Alvarez Ronquillo made a few arguments, but the most persuasive counter to me is that the term should only encompass the trafficking of illegal firearms. He wasn't doing that. He was illegally trafficking in legal firearms. Sneaky, sneaky. Rejected. Trafficking need not always involve illegal goods, explains the Fourth Circuit, relying on quite a few things for that. Relatedly, the trafficking need not be for illegal use, explains the court, although there is some support for this in the sentencing guidelines used in federal court and another federal statute. But this aggravated felony provision doesn't cross-reference either of those things, explains the Fourth Circuit. Very smart arguments being made, but they were rejected. The plain meaning means unlawful trading or dealing in firearms. And that was essentially the end of Mr. Alvarez Ronquillo's case. His criminal conviction at Section 922A1A states, quote, "It shall be unlawful for any person, except a licensed importer, licensed manufacturer, or licensed dealer, to engage in the business of importing, manufacturing, or dealing in firearms, or in the course of such business to ship, transport, or receive any firearm in interstate or foreign commerce," end quote. Now, at a minimum, explains the court relying on the Third Circuit, this is a, quote, "regulatory licensing offense," end quote. So, not the worst crime in the world, the least culpable conduct that is. It's a regulatory offense. But even so, such an offense still qualifies as the unlawful trading or dealing. Regulatory and licensing violations are, after all, unlawful. Nor need it even involve monetary consideration, explained the court, as this conviction allows if, say, repeated criminal or terroristic purposes are the aim. Quote, "One must still engage in the regular and repetitive purchase and disposition of firearms," end quote. And that is enough for the aggravated felony statute. Plus, the defendant in such a scenario must still first purchase the firearms somewhere, so there is some consideration happening at some point. That all made Mr. Alvarez Ronquillo removable, which is why the Fourth Circuit said he lost his case. And that is Alvarez Ronquillo v. Bondi. Moving on to matter of Salas Pena, published by the BIA. Hello, BIA. No bond decision adverse to non-citizens until Thursday of the week. I was beginning to get concerned. The Attorney General came through, though, and designated this unpublished decision precedential on Thursday. An immigration judge granted Mr. Salas Pena a $5,000 bond. The BIA hates it. That is because Mr. Salas Pena has an arrest on September 4th, 2007 for open container speeding and driving without a license, and an arrest on October 4th, 2022 for trafficking in approximately 2,077 grams of cocaine. But remember, arrest, no conviction. The IJ found that the, quote, "police report related to this 2022 arrest lacked indicia of reliability regarding the pending charges against the respondent," end quote. Specifically, the IJ, quote, "found that the criminal charge was tenuous because no drugs were found on respondent, and he was merely implicated by a woman who had accepted a FedEx parcel containing the cocaine," end quote. That trace amounts of cocaine were found on 35 $100 bills in his apartment was not sufficient to the IJ either. And again, no conviction. Query why not, though, right, with a 2022 arrest? The BIA mentions that charges remain pending, but man, that has been a long time. I feel something is up. A conviction or lack thereof isn't the end of the story, and DOJ has made up rules giving non-citizens the burden in bond proceedings, so the BIA dove in and overturned the IJ de novo. It likes the police report. That's about it. And, quote, "Further, a subsequent search of the respondent's residence revealed a handgun inside a safe, a bank envelope containing $384.51, and a plastic bag containing an unknown white powder in the location where a canine gave a positive alert," end quote. Given that and the, quote, "serious nature of the offense," end quote, the BIA held that Mr. Salas Pena didn't meet his burden on dangerousness. So it kept him detained on DHS's appeal. Peak recent First Circuit decisions, though, on how police reports can be attacked, including when they're not quite as reliable as the BIA is saying that this one is here. Even when non-citizens have the burden, those First Circuit decisions. And that is matter of Salas Pena. We are now on to Hernandez Flores v. Bondi, published by the Second Circuit on August 14th, 2025. This case is about continuances and ineffective assistance of counsel. Mr. Hernandez Flores is from Mexico and entered the United States 4 times without authorization between 2003 and 2004. In removal proceedings in 2018, an IJ gave him 3 continuances, including for attorney prep. He then asked for a fourth continuance based on the fact that his girlfriend was about to give birth, which would make him potentially eligible for non-LPR cancellation of removal, given that he'd now have a qualifying relative. An immigration judge denied, but set the final hearing to discuss pre-conclusion voluntary departure to a date after the girlfriend's due date. The girlfriend gave birth and a continuance motion followed. It was denied. Seems like maybe the IJ would have granted a continuance at the hearing, but Mr. Hernandez Flores didn't have the birth certificate yet. Now, having recently had a child myself, that certainly tracks, at least in California. It took many weeks. But also, the IJ didn't see sufficient hardship, even prima facie, it seems. Not desiring voluntary departure, Mr. Hernandez Flores was ordered removed. The BIA affirmed. He then filed a motion to remand based on ineffective assistance of counsel, claiming he had not been advised that he could have married his girlfriend to get that qualifying relative way back when. Indeed. Well, not the girlfriend per se, but apparently her teenage son is a U.S. citizen, and that would, so the argument goes, give Mr. Hernandez Flores a U.S. citizen child, or, I guess, stepchild. The BIA denied the motion and dismissed the appeal. And the Second Circuit affirmed. But hey, at least it held, unlike the 11th Circuit, I believe, in its own Flores decision from a couple of years ago, that it had jurisdiction to review a denial of a continuance or a motion to reopen tethered to a non-LPR cancellation of removal denial. Patel notwithstanding. And that's Ponce Flores v. U.S. Attorney General. The Second Circuit did, however, affirm denial of the continuance. Jeff Sessions' matter of LABR decision permits a review of the legitimacy of relief eligibility during the continuance analysis, where possible and applicable. And here to the court, Mr. Hernandez Flores, quote, failed to introduce sufficient evidence to support his eligibility for relief, end quote, in his continuance motions. Cancellation, that is. Turning then to ineffective assistance of counsel. Same standards as the Fourth Circuit case that we started the episode with. But also in the Second Circuit, quote, we strongly presume that counsel rendered adequate assistance and made all significant decisions in the exercise of reasonable professional judgment, end quote. Supreme Court quote there, actually. Here, even assuming the attorney had not advised about the possibility of marriage to get the qualifying relative stepchild, the Second Circuit doesn't believe there a reasonable likelihood that it would have changed things. There is no evidence to, quote, suggest that the child's mental health issues would have risen to the level of exceptional and extremely unusual hardship, end quote. The most presented, apparently, was attorney argument in the motion and papers, and that is not evidence explains to court. Nor does the Second Circuit even believe former counsel incompetent, given that, quote, marriages entered into removal proceedings are presumptively fraudulent, end quote. Harsh way to say that rule, quoting the BIA to be fair, but it's not completely wrong. Judge Park would find that the court lacked jurisdiction to review the continuance stuff. Patel. But that is not the majority decision. Still a loss for the non-citizen, though. And that is Hernandez Flores v. Bondi. Two from the Fifth Circuit now. First, Romero-Lozano v. Garland, published by the Fifth on August 12, 2025. This case is about review of the denial of withholding of removal in withholding-only proceedings. Mr. Romero-Lozano was ordered removed and removed from the United States in 2014 and entered unlawfully 8 years later. When apprehended, DHS reinstated that old final order of removal on May 20th, 2022. After he passed a reasonable fear interview, ICE placed him in withholding-only proceedings as the statute designates. An immigration judge ultimately denied that relief and protection, and the BIA affirmed on November 27, 2023. So over a year later, after the reinstatement. Well within 30 days of the BIA affirmance of that, Mr. Romero-Lozano petitioned for review the denial to the Fifth Circuit. Something completely within the rules at the time and as would be expected. Then the parties jointly moved to remand to the BIA, something the Fifth Circuit granted. The case therefore remains pending before the BIA, a very unique procedural posture for the Fifth Circuit to do anything with. But do something the Fifth Circuit did on Mr. Romero-Lozano's motion. Freaking out after the Supreme Court's Riley decision, clearly, he moved the Fifth Circuit to, quote, recall the mandate, reinstate his petition, and hold it in abeyance until the BIA completes its remand proceedings, end quote. Clearly, Mr. Romero-Lozano is worried that if he doesn't take action now, the Fifth Circuit might rely on that to ultimately dismiss his petition for review as untimely, given what the Supreme Court just said in Riley. To do such a thing, the Fifth Circuit explains, extraordinary circumstances must be present. That is, for it to take back a remand from the agency. The court doesn't see them here, because the Fifth Circuit has decided to expand Riley from the Farrow context, which that decision originated from, and into the withholding-only post-reinstatement context, as I have feared would occur because it is the natural reading of that decision, that is, Riley and this whole framework. It took less than 2 months, everyone. Although it's only a partial extension, it could have been a lot worse. Let me explain. To the court, Mr. Romero-Lozano's case falls squarely within Riley, end quote. Even though Mr. Romero-Lozano's petition for review was timely when he filed it under then effective Fifth Circuit precedent, explains the court, it has all now changed. The Fifth Circuit reads Riley as holding that a petition for review is due 30 days post-final order of removal, which is true, but Riley didn't regard a reinstatement case. Here, the Fifth Circuit does not decide, quote, whether Riley applies retroactively to cases that were timely when filed but would now be untimely under Riley. That weedy question is better left to a merits panel, not to a motion to reinstate, end quote. But it doesn't really matter to the court. The Fifth Circuit very much seems to be holding that 30 days began post-reinstatement of the final order on May 20th, 2022. So big sigh of relief, even though the technical final order thing was really in 2014. The petition for review is still now untimely post the Fifth Circuit's extension of Riley to the reinstatement context, and reinstating the petition for review now won't cure that. Mr. Romero-Lozano didn't petition for review 30 days post-reinstatement in 2022. Following Fifth Circuit rules at the time, he waited until the entire withholding-only process played out. So the court denied the motion. Although it is not preordained that Mr. Romero-Lozano will lose his petition for review in chief. A comment. So like I said, I suppose it could have been worse. I suppose the Fifth Circuit could have held that under Riley, the petition for review deadline, even in reinstatement cases, is 30 days post final order of removal, which here would have been 2014, not 2022. The Fifth Circuit did not adopt that very unfair rule. But it did seem to implement a problem similar to the Farrow problem from Riley itself. It seems that the Fifth Circuit would have people like Mr. Romero-Lozano immediately petition for review ICE's reinstatement decision. It's an immediate petition for review because you can't challenge the decision to reinstate before an IJ or the BIA. Not only that, a petition for review would maybe be frivolous. There's no doubt, after all, that Mr. Romero-Lozano is subject to reinstatement. And he would need to do it, likely, before he even had his first withholding-only hearing. Heck, maybe even before a final decision on his reasonable fear. So not only do you have an ethical problem, petition for review counsel, but because it might be frivolous, the petition for review might be summarily dismissed by the Fifth Circuit. After all, Mr. Romero-Lozano has no basis to challenge reinstatement, at least that I'm aware of. He would only be doing it to proactively save circuit review on his withholding of removal claim down the road, should he lose before the IJ and the BIA. Nothing forces the Fifth Circuit to stay proceedings while the withholding of removal process plays itself out. It is all absolutely wild and exceptionally expensive. Don't get me wrong, this is all a wild problem largely created by Riley itself. But a wild problem it is. NYLA is involved in all of this, and I have promoted them on the podcast before. And Trina Romuto came up with a lot of viable reasons to challenge reinstatement that could go all the way up to petition for review, calling me when I emailed her a, quote, Debbie Downer, end quote. I did not like that, I will admit. If you've got a similar case or a question, hit up NYLA. Link in the show notes. And that is Romero-Lozano v. Garland. Final case before we take a break. Montiel Rubio v. Bondi, published by the Fifth Circuit on August 13, 2025. This case is about Convention Against Torture protection. Marco Rubio, Mr. Rubio, is a 60-year-old Venezuelan who overstayed a tourist visa in 2019. He applied for asylum before it expired, though. Ended up in removal proceedings. Mr. Rubio, not Marco Rubio, claimed he was a member of the Primero Justicia party and opposed the Maduro regime. He testified that he participated in about 40 protests between 2010 and 2019, and that he feared the regime and colectivos that it supports and uses to do its dirty work. At one such protest in 2015, Mr. Rubio was shot in the leg by colectivo members. Sounds like harm rising to the level of past persecution to me. They threatened to kill him, too. Similar during a protest roadblock-type event in 2017, where colectivo members threatened to burn Mr. Rubio alive. Mr. Rubio, however, traveled to America 3 times between 2017 and 2018 and never sought asylum, the Fifth Circuit notes. The triggering event for asylum, it seems, was a 2019 protest where colectivos took photos of protesters and the National Guard dropped tear gas. Mr. Rubio got wind that someone who he believed was with the colectivo was looking for him in his neighborhood, and he fled the United States. And yet still he intended to return to Venezuela, he testified. But while here, the neighbor relayed that the colectivo had shot at him, thinking that he was Mr. Rubio. Seems like a strong asylum case to me. An immigration judge denied, somehow finding that getting shot in the leg and the threats didn't rise to the level of past persecution. Other findings, of course, too. Mr. Rubio recovered from getting shot after all, reasoned the IJ, and it all occurred over a 9-year period. Cat protection denied as well, and the BIA affirmed. And you know what? So did the Fifth Circuit. The panel believes it owes EOIR quite a bit of deference in the asylum realm, and the harm suffered or feared needs to be, quote, extreme, end quote. That is, to be past persecution. Although for what it's worth, it seems, all tribunals are correctly taking it for granted that the colectivos in Venezuela are sufficiently an arm of the Venezuelan state. So there's that, I suppose. But deny it did. True, quote, citing persuasive case law, Mr. Rubio also contends that the series of events that happened to him indicate a broader pattern of being targeted by state-associated forces, end quote. But Mr. Rubio healed from his wounds, explained the Fifth Circuit. And it was all nearly a decade ago. And a, quote, single violent event where an applicant experienced physical harm because of his membership in a particular social group did not necessarily constitute persecution, end quote, that is, in another case. Even if it's a life-threatening bullet wound. The panel believes that even here, a, quote, showing of targeted and sustained attempts of harm, end quote, is additionally required for a past persecution showing. The Fifth Circuit believes that the Eighth and Seventh Circuits would agree. By the way, to the court, the, quote, prototypical example, end quote, of a winning past persecution asylum claim is Tamara Gomez v. Gonzalez from the Fifth Circuit in 2006, 447 Fed 3rd 343. So note that and rely on it if it helps you. Remember Gonzalez? The court explains further that unlike other circuits, death threats aren't part of the past persecution analysis, but only go to the question of future persecution. Oof. Insufficiently concrete here anyway. So too, Mr. Rubio's long time remaining in Venezuela cuts against him, explains the court. On to future persecution without past persecution, and in addition to not thinking much of the death threats, the Fifth Circuit appears to agree with the IJ that Mr. Rubio is not an important enough political figure to have a well-founded fear of return to Venezuela. And explains the court he's avoided the colectivos before. Concluding with cat protection then, well, if a gunshot and being gassed and collectivo threats doesn't constitute past persecution of the Fifth Circuit, they're not going to constitute torture either. Stating that the IJ and the BIA did enough, the Fifth Circuit denied one heck of a petition for review. And that is Montiel Rubio v. Bondi. Immigration attorneys. Once you've secured a bond, let Gonzalez & Gonzalez Immigration Bonds take it from there. They help families post immigration bonds quickly, easily, and with full support every step of the way. Sure, you can post directly with DHS, But that means no guidance, no help when something goes wrong, and a 4 to 6 month wait for a refund. With Gonzalez & Gonzalez, families get hands-on help throughout the entire process, and they typically issue refunds within 1 to 2 weeks of receiving the I-391 bond cancellation notice. Tired of being the point of contact for every bond question? Let Gonzalez & Gonzalez take those calls. They'll handle the paperwork, the system issues, and the family's concerns, so you can focus on what really matters, winning the case and helping your client stay in the country. You can reach Gonzalez & Gonzalez at 833-409-9200. Their fee? Just 2% plus $40. And for bonds of $10,000 or more, they can defer the fee and deduct it from the refund. Financing options? They got those too. They're family-owned and have been in business for 75 years. Gonzalez & Gonzalez Immigration Bonds. Efficient, supportive, and trusted. Visit immigrationbond.com, click on the link in the show notes, or call at 833-409-9200. Are you fighting like a maniac, completely overwhelmed by the chaos of the new administration? Immigration policies are shifting fast, the pressure is piling up, and clients are desperate for help. You're working around the clock, but there's only one of you. Well, Staffy's got your back. Staffy's bilingual virtual paralegals and administrative assistants handle U.S.CIS forms, client intake, evidence gathering, and scheduling, so you're not drowning in paperwork while trying to fight for your clients at the same time. Stop running on empty. Staffy gets you a trained, ready-to-go team fast with HR-backed support, onboarding, and continuous training. You don't have time to do it all alone, and you don't have to. Schedule a consultation at staffy.cc, that's stafi.cc, and claim $500 off your first month. Welcome back. We are just getting started. Got a whole nother episode pretty much ahead of us if it was any other week. Suchi Salguero, the Attorney General of the United States, published by the Third Circuit on August 14, 2025. This case is about motions to reopen. Mr. Suchi Salguero is from Guatemala, has been here for a long time, and applied for non-LPR cancellation of removal in removal proceedings because that's pretty much the only form of relief available for lots of people in removal proceedings. An IJ held that he couldn't establish the hardship to his then only qualifying relative, his 7-year-old U.S. citizen son. But actually, that was the alternative holding. The IJ's first holding was that he hadn't established that it was even his son at all, that he was the father of the child. He appealed to the BIA, and 2 months before the BIA ruled, Mr. Suchi Salguero welcomed a baby girl. After the BIA dismissed the appeal, he timely moved to reopen, alleging that new and previously unavailable evidence, to wit, that baby, now made him cancellation eligible. The BIA denied, saying it wasn't actually new evidence because the baby was born while the appeal was pending, and in any event, Mr. Suchi Salguero hadn't established the relevant hardship. On reconsideration, the BIA doubled down. Yes, the regulation requires that the new evidence not have been available at the former hearing, that is, to get a motion to reopen granted, but the BIA read that as to include proceedings before the BIA too, not just hearings before the IJ. Weird. The Third Circuit wasn't having any of that. No Kaiser deference to the BIA's interpretation of its regulation at 8 CFR section 1003.2C1. That reg requires that a motion to reopen be based on, quote, new facts, supported by evidence that is material and was not available and could not have been discovered or presented at the former hearing, end quote. The statutory and regulatory history makes clear that former hearing refers to the last hearing before the immigration judge, not the BIA, explains the Third Circuit. Heck, the regs don't even let non-citizens present new evidence on appeal, right? Notes the Third Circuit. And there are no hearings before the BIA. We all know that. Pulling absolutely no punches, the court states, quote, the interpretation advanced by the BIA does violence to the plain language of the regulation and is inconsistent with the regulatory structure for fact-finding and appellate review, end quote. I mean, I don't like the BIA's holding here either, guys, but man. Nevertheless, despite this clear error, the court will not be granting the petition, as it sees the error as harmless. In its decision, after all, the BIA did also say that Mr. Sushit Salguero hadn't established a prima facie case of extreme and exceptionally unusual hardship to the new child. The Third Circuit seems to agree, given the apparent lack of evidence of hardship to this new baby in the record. And for that reason, it affirmed the BIA. But remember the BIA's first error, everyone. And that is Sushit Salguero, the Attorney General of the United States. Next up is Roman Sanchez, the Attorney General of the United States, published by the Third Circuit on August 15th, 2025. Really tying this week together, this case is about asylum and non-LPR cancellation or removal. Because these are like the only things that most people who enter the U.S. without authorization can apply for in immigration court. Barring exceptions, yes, I know, there are exceptions. Mr. Sanchez is from Mexico and has lived in the United States for like 25 years. He's got quite a few criminal charges and a DUI conviction, which landed him in removal proceedings where he applied for the aforementioned relief. An immigration judge denied cancellation for lack of good moral character and other reasons. Asylum denied too, as 23 years untimely. The BIA affirmed that and deemed that Mr. Sanchez had actually waived the issue on appeal. The Third Circuit affirmed the agency. It agreed that a challenge to the untimely asylum application had been waived, so asylum's gone. Under withholding of removal then, which has no time limitation, his claim was based on being an Americanized Mexican. But actually, he didn't meaningfully challenge that denial either to the BIA, so the Seventh Circuit similarly deemed it waived. Turning then to the denial of non-LPR cancellation. Looks like Mr. Sanchez has multiple DUIs. Attorney General Barr said that makes someone presumptively lack good moral character in matter of Castillo-Perez, if they occurred during the good moral character period, which they did here. Mr. Sanchez did not challenge the propriety of this Attorney General-created presumption, which I had very much hoped he would have, and that is what this case would have been about. Instead, he argued that the IJ had precluded him from rebutting it when the IJ prevented him from having his wife and psychologist testify, who would have linked the alcohol problems to psychological issues and then, I guess, presumably undermined the fact that it demonstrated a lack of good moral character. Well, like the BIA before it, the Seventh Circuit doesn't think this is a due process violation because it wouldn't have changed the IJ's conclusion, that is, if these people had testified. So no prejudice in legalese. Viewing the good moral character record that had actually been submitted, quote, his scholastic achievements and rehabilitative efforts are insufficient to rebut the presumption that he did not have a good moral character because the record shows that the DUI convictions were not an aberration given their frequency of his convictions, end quote. And that's the end of it. And that is Roman Sanchez, the Attorney General of the United States. Good news for you still with me. We have reached the last circuit. Bad news for those who want to leave. There are 3 decisions out of the 7th Circuit. The first one, Rivas v. Bondi, published by the 7th on August 11th, 2025. This case is about asylum. Miss Rivas and her minor son are from Nicaragua and sought asylum in immigration court. She testified that she and her family operated a pharmacy there. When protests against the ruling Sandinista government began in April 2018, Ms. Rivas, quote, provided indirect support to the opposition movement by giving small but repeated amounts of money, medicine, and supplies to people associated with the protests, including a local doctor, the family of injured protesters, and a pastor who distributed funds to protesters in need of medical treatment, end quote. Ms. Rivas herself supports the opposition Partido Liberal Constitucionalista, or PLC, but has never formally joined or donated money. Nor was Ms. Rivas ever physically harmed or directly threatened before leaving Nicaragua, although a shooting did occur that hit the family's home-based pharmacy. Quote, since her departure, people associated with the government have come to the pharmacy and asked about her brother, who was actively involved in the protests, and another family member, but not Ms. Rivas, end quote. And her mother's an active PLC member and continues to live in Nicaragua and support the opposition through the pharmacy. So that's not looking great for an asylum case, at least as described in this decision, and in light of how asylum law has developed over the last 4 decades. An IJ and the BIA denied Ms. Rivas' claim, and the Seventh Circuit affirmed. Given the lack of fears specific to Ms. Rivas, she brought a pattern or practice of persecution theory for asylum. Her pattern or practice claim was based on her asserted membership in 2 proposed social groups, professionals who provided healthcare to protesters and/or opponents of the Sandinistas. But a pattern or practice requires a high standard, explains the Seventh Circuit, because once found, literally all members of the group, religion, what have you, are due asylum. Quote, to prevail in a pattern or practice claim, an asylum applicant must show that there is a systemic, pervasive, or organized effort to persecute members of the protected group, and this effort must be perpetrated or tolerated by state actors. End quote. On to the first group. Apparently, reports show that the Sandinista regime fired medical professionals who helped the opposition and even harassed and threatened and intimidated some. But to all tribunals, it's not bad enough to be persecution, at least on the generalized scale to all medical professionals. As to opponents of the Sandinistas, which would be millions in Nicaragua, I imagine, well, quote, proposing a very broad defined social group does not necessarily doom the claim, end quote. Again, as I always say, because that's what began asylum law to begin with. Think German Jews in 1933. Broad groups do, however, quote, make it harder to establish systemic, pervasive, and organized persecution, end quote. Even substantial hardship for a group as a whole won't do. Unsatisfied to the Seventh Circuit here, quote, we do not minimize the Sandinistas' repression of open opposition or even peaceful protest, but the evidence does not compel us to conclude that passive dissenters like Ms. Rivas, who have neither participated in the protests nor joined the opposition party, face systemic future persecution, end quote. Quite a few qualifiers there, though, everyone, if you're listening closely, for your more actively political Nicaraguan asylum seeker clients. Plus here, right, the mom still lives there? Explain the court. And Ms. Rivas doesn't actually know who shot the house or why. And the family was pretty safe because they paid for private security. With asylum and withholding of removal denied, the Seventh Circuit turned briefly to gag protection and affirmed denial of that too. No pattern or practice theory even allowed there, and without individualized harms or specific fears, the court made quick work of the cat claim. And that is Rivas v. Bondi. Moving on to Santos-Mendoza v. Bondi, published by the Seventh Circuit on August 14th, 2025. Lots of cancellation type cases this week if you haven't picked it up yet, and this is another one about hardship. Mr. Santos-Mendoza is from Mexico, has been here almost 20 years, and has 2 U.S. citizen children, plus a U.S. citizen stepchild. Not the first appearance of one of those on this week's podcast. Seems like Mr. Santos-Mendoza is a good dude and is the main financial supporter for the family, although his wife does make not insignificant money. And his wife has been the victim of domestic violence in the past and so relies heavily on Mr. Santos-Mendoza and is grateful for him, although she is not a U.S. citizen, it seems. Everyone loves this guy, and he's a great father. The IJ likes him too. The U.S. sought to remove him after he was arrested for driving on a suspended license and leaving the scene of an accident, which I certainly don't condone, but let's be honest, it's probably because he was scared of what would happen to him if he remained at the accident, which is exactly what happened to him. The IJ denied cancellation based on an insufficient hardship finding, and the BIA affirmed. Believing that a sufficient mixed question of law and fact, the Seventh Circuit reviewed it, didn't want to jump into the budding, nerdiest circuit split of all time regarding which deferential standard of review should apply to the post-Wilkinson hardship question, because applying either, it believed great dude Mr. Santos-Mendoza lost his case correctly. Interesting quote, the hardship determination is inherently comparative, but the IJ and board must consider individual hardships on their own terms. Generalizations will not do, end quote. Here, the court believed the IJ considered all appropriate factors. The children's anxieties about losing their awesome father are, quote, alas, all too common for a family in removal proceedings, end quote. And the kids are doing great otherwise. Insufficient psychological hardship explains all courts. Regarding the financial stuff, and although Mr. Santos Mendoza is the primary breadwinner, the Seventh Circuit didn't believe reversal mandated. Plus, it can be mitigated when and if he gets a job in Mexico, and maybe the wife could get a better job in America. Not crazy things for the agency to find, reasoned the Seventh Circuit. Quote, we do not intend to minimize the severity of the financial and emotional harm that Mr. Santos Mendoza's removal will cause his family. It is an unfortunate reality that these consequences are common in these cases, end quote. And so the Seventh Circuit denied the petition for review. And that is Santos Mendoza v. Bondi. I know you never thought it was going to happen, but we have reached the end with Martinez v. Bondi, published by the Seventh Circuit on August 14th, 2025. This case is about asylum, and it's an interesting one. Miss Martinez is from Honduras. She grew up on a land cooperative where her father farmed African oil palm. But in 1989, her father and other co-op members were tricked into selling their land in a bad deal. Stripped of their land, Miss Martinez left home to live with her boyfriend at 14 years old, with whom she ended up having 4 children. Very unhappy about what had happened to her, Miss Martinez eventually, quote, joined the Unified Movement of Farmers of the Aegean, or MUCA, a grassroots coalition of former cooperative members who believed the land sale had been illegal. MUCA demanded land reform and staged mass protests that pressured the government to grant the group use of a vacant parcel, now known as La Confianza, in 2008, end quote. Miss Martinez moved to the land with other MUCA families, built a home, and they elected a board of directors, and they all began cultivating African palm in the reclaimed land. What a win! Love the success story. Things went smoothly until 2015. That's when co-op president, Mr. Rodriguez, started doing shady stuff and even created a bit of an armed militia for himself. MUCA members were found dead. Miss Martinez blames Mr. Rodriguez. MUCA successfully moved to remove him, but serious threats were made by his armed people during the process. Scared, Miss Martinez fled to America with one of her sons. MUCA members and Mr. Rodriguez's successor president were murdered after she left. And although some of Mr. Rodriguez's associates have been arrested and convicted, he remains at large and is wanted in Honduras for at least 2 murders. How about this case? The family remains behind, however, and it's been nearly a decade since these events occurred, as so often happens in asylum because it takes so long to decide these cases. Deemed credible in removal proceedings, an IJ denied and the BIA affirmed. Only asylum and withholding of removal are on petition for review to the Seventh Circuit, which affirmed the agency. And by the time it came to the Seventh, it all came down to unable or unwilling to protect and reasonable relocation. Seems like Miss Martinez didn't challenge the no past persecution finding, meaning it's her burden to establish both of these things in relation to a future persecution claim. Recall, when non-government actors like Mr. Rodriguez are feared, the asylum seeker must establish that the government is unable or unwilling to protect. Quote, a government is not unable or unwilling to protect its citizens from persecution simply because its efforts are imperfect. What matters is whether the government makes a genuine attempt to control the persecutors. End quote. Isolated failures won't cut it to the panel. Unsatisfied here. Not only does the Seventh Circuit see a record that shows decreasing violence in Honduras, but the Honduran government has had success going after Mr. Rodriguez's associates, even if they haven't caught him. And Miss Martinez never reported it anyway, explains the court. Dinged. Whether Miss Martinez can reasonably relocate in Honduras remains her burden because she hasn't suffered past persecution. Unmet as well, explained the court. In the Seventh Circuit, quote, the reasonableness determination depends on the totality of circumstances, including the size of the country of nationality, the geographic locus of the alleged persecution, the size, numerosity, and reach of the alleged persecutor, and the applicant's demonstrated ability to relocate to the United States in order to apply for asylum, end quote. That's an interesting final consideration, no? That's kind of always going to cut against the asylum applicant, right? Here, all of this was happening in the new Muka commune place, one single location. Although one Muka member had been harmed outside of the commune, the Seventh Circuit believes reasonable the IJ's finding that, quote, that victim was targeted because he possessed sensitive information about Mr. Rodriguez's criminal activity. That is, unlike Ms. Martinez, who admitted she holds no similar insider information, end quote. Pretty nuanced finding. And also, Ms. Martinez has family still living in Honduras, reasoned the courts. And for all of these reasons, the Seventh Circuit denied the petition. And for all of those reasons, we conclude our massive week of cases. And that is Martinez v. Bondi. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzelli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. And we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.